Appeal. The formal process by which a party who is dissatisfied with the trial court's judgment or ruling asks a higher court to review the decision for legal error, conducted entirely on the written record from the trial court without the presentation of new evidence or witness testimony. Appellate court. A court with the authority to review decisions made by lower trial courts, focusing exclusively on questions of law rather than questions of fact, and having the power to affirm, reverse, vacate, or remand the lower court's decision. Trial court. The court of original jurisdiction where cases are first heard, evidence is presented, witnesses testify, and the initial verdict or judgment is rendered, whose decisions are subject to review by higher appellate courts. Court of Appeals. An intermediate appellate court that reviews trial court decisions before they may be considered by the highest court in the jurisdiction, typically sitting in panels of 3 judges who decide cases based on written briefs and oral argument. Supreme Court. The highest court in a jurisdiction, either a state or the federal system, whose decisions on questions of law are final and binding on all lower courts within that jurisdiction, and which typically exercises discretionary jurisdiction over which cases it will hear. Jurisdiction. The legal authority of an appellate court to hear a particular appeal, which may be mandatory, requiring the court to hear certain categories of cases, or discretionary, allowing the court to choose which cases it will review. Mandatory jurisdiction. The category of appeals that an appellate court is legally required to hear and decide, typically including direct appeals from final judgments in criminal cases and certain categories of civil cases specified by statute. Discretionary jurisdiction. The authority of a higher court to choose which appeals it will accept for review, exercised through the writ of certiorari at the Supreme Court level and through similar mechanisms at other courts with discretionary dockets. Final judgment rule. The general principle requiring that a party wait until the trial court has issued a complete and final resolution of all claims before filing an appeal, preventing piecemeal appellate review of preliminary rulings during the course of litigation. Interlocutory appeal. An appeal of a trial court's ruling made before the case has reached final judgment, permitted only in limited circumstances, such as rulings on injunctions, class certification, or matters involving controlling questions of law, as an exception to the final judgment rule. Notice of appeal. The formal document filed with the trial court within a specified deadline, typically 30 days of the final judgment in civil cases and 14 days in criminal cases, that initiates the appellate process and vests jurisdiction in the appellate court. Appellant. The party who lost at the trial court level and is seeking review of the adverse decision in a higher court, bearing the initial burden of demonstrating that a reversible error occurred in the proceedings below. Appellee. The party who prevailed at the trial court level and must defend that victory in the appellate court, arguing that the lower court's decision was correct and should be affirmed. Cross appeal. An appeal filed by the party who initially won but is dissatisfied with some aspect of the judgment, such as the amount of damages awarded, allowing both parties to challenge different aspects of the same trial court decision simultaneously. Record on appeal. The complete official transcript of all trial court proceedings, including all pleadings, motions, evidence, testimony, rulings, and orders, that forms the exclusive basis for appellate review since appellate courts do not hear new evidence. Appendix. A compilation of the most relevant portions of the trial court record submitted by the parties along with their appellate briefs, allowing the appellate judges to readily access the key documents and transcript excerpts central to the issues on appeal. Appellate Brief. The formal written legal document submitted by each party to the appellate court presenting the facts, procedural history, legal issues, arguments, and authorities supporting their position, serving as the primary vehicle for appellate advocacy. Opening brief. The appellant's first brief submitted to the appellate court, setting forth the issues on appeal, the relevant facts and procedural history, the legal standards of review, and the arguments supporting reversal or modification of the lower court's decision. Answering brief. The appellee's responsive brief addressing the arguments raised in the appellant's opening brief, presenting counter-arguments, distinguishing cited authorities, and urging the appellate court to affirm the trial court's judgment. Reply brief. The appellant's final brief responding to the arguments made in the appellee's answering brief, limited to addressing those arguments without introducing entirely new issues not raised in the opening brief. Amicus Curiae brief. A brief submitted by a person or organization that is not a party to the appeal but has a strong interest in the outcome, offering additional perspective, specialized expertise, or broader policy considerations to assist the court in its deliberations. Statement of issues. The section of an appellate brief identifying the specific legal questions the court is being asked to resolve, framed in a way that highlights the alleged error below and previews the argument that reversal is warranted. Statement of facts. The section of an appellate brief presenting the factual background of the case drawn from the trial court record, required to be accurate and supported by specific citations to the record, even when presenting the facts in the light most favorable to the client. Argument section. The central substantive portion of an appellate brief in which the attorney presents their legal arguments in support of their position, organized under point headings, supported by case citations and statutory authority, and applying the law to the facts of the record. Point heading. A concise declarative statement appearing in bold at the beginning of each major argument section in an appellate brief, summarizing the legal conclusion the attorney is urging and designed to allow the court to understand the argument at a glance. Citation. A reference to a legal authority, such as a court decision, statute, regulation, or secondary source, included in an appellate brief to support a legal proposition, formatted according to the citation rules applicable in the jurisdiction. Oral argument. The live presentation made by attorneys before a panel of appellate judges after the briefing is complete, allowing each side a limited time, typically 10 to 30 minutes, to highlight key arguments and answer questions from the bench. Hot bench. An appellate panel whose judges come to oral argument thoroughly prepared and actively engaged, asking numerous probing questions rather than allowing counsel to deliver a prepared speech, considered a sign of judicial engagement with the issues. Cold bench. An appellate panel that asks few or no questions during oral argument, leaving counsel to present their prepared argument with little judicial interaction, which may signal either that the court has already decided the case or that the issues are straightforward. Moot court. A practice session simulating oral argument before a mock appellate panel used by attorneys to prepare for actual appellate arguments by anticipating judicial questions and refining their presentation of the key issues. Standard of review. The degree of deference an appellate court gives to the trial court's decision when evaluating whether an error occurred, varying based on the nature of the ruling being reviewed and fundamentally shaping the difficulty of winning on appeal. De novo review. The most searching standard of review applied to pure questions of law under which the appellate court examines the issue fresh without any deference to the trial court's conclusion, essentially deciding the legal question anew as if it had not been addressed below. Abuse of discretion. A deferential standard of review applied to trial court decisions that are within the judge's discretion, such as evidentiary rulings, sanctions, and case management decisions, overturning the decision only when it is clearly unreasonable, arbitrary, or beyond the range of permissible choices. Clearly erroneous. The most deferential standard of review applied to the trial court's factual findings in a bench trial, overturning those findings only when the appellate court has a definite and firm conviction that a mistake was made based on the entire evidence. Substantial evidence. A standard of review applied to administrative and jury decisions requiring the appellate court to affirm if the record contains sufficient evidence that a reasonable fact finder could have reached the same conclusion, even if the appellate judges might have decided differently. Plain error. A standard permitting appellate review of errors that were not objected to at trial, and therefore not preserved, only when the error is obvious, affects substantial rights, and seriously undermines the fairness or integrity of the judicial proceedings. Harmless error. An error that occurred during trial, but did not affect the outcome or the substantial rights of the parties, insufficient to justify reversing the verdict because the same result would have been reached even without the error. Reversible error. An error that was sufficiently serious that it likely affected the outcome of the trial and the substantial rights of the parties, providing grounds for the appellate court to reverse the verdict and order a new trial or other relief. Mixed question of law and fact. An issue requiring the application of a legal standard to specific facts, for which courts apply a sliding standard of review depending on whether the legal or factual component predominates in the particular question presented. Preservation of error. The requirement that a party raise an objection or issue in the trial court in order to preserve the right to raise it on appeal, reflecting the principle that appellate courts should not be the first forum to address legal issues that could have been corrected below. Affirm. The appellate court's decision upholding the trial court's judgment in whole or in part, finding that no reversible error occurred and that the lower court's ruling was legally sound and should stand. Reverse. The appellate court's decision overturning the trial court's judgment in whole or in part, finding that a reversible error occurred that warrants a different outcome, often accompanied by a remand for further proceedings. Remand. The appellate court's order sending the case back to the trial court for further proceedings consistent with the appellate decision, which may require a new trial, additional findings, or recalculation of damages. Vacate. The appellate court's nullification of the trial court's judgment, order, or verdict, rendering it void and without legal effect, typically preceding a remand for new proceedings to address the identified error. Modify. The appellate court's adjustment of the trial court's judgment without reversing it entirely, such as reducing a damages award, narrowing the scope of an injunction, or correcting a specific aspect of the sentence imposed. Dismiss. The appellate court's termination of an appeal without reaching the merits, typically because the court lacks jurisdiction, the appeal was untimely, the issue has become moot, or the party lacks standing to pursue the appeal. Affirm in part, reverse in part. An appellate disposition upholding some aspects of the trial court's judgment while reversing others typically issued when the lower court reached the correct result on some issues but erred on others. Remand with instructions. A remand order specifying precisely what the trial court must do on remand, limiting the lower court's discretion and directing a particular outcome or requiring specific additional findings or proceedings. Opinion. The written explanation of an appellate court's decision setting forth the facts, legal issues, reasoning, and conclusions that led the court to its disposition, serving as binding precedent for future cases in the jurisdiction. Majority opinion. The opinion joined by more than half of the judges on an appellate panel representing the official holding of the court and constituting binding precedent that lower courts within the jurisdiction must follow. Concurring opinion. An opinion written by a judge who agrees with the majority's outcome, but for different or additional reasons, not constituting binding precedent, but potentially influencing future development of the law. Dissenting opinion. An opinion written by one or more judges who disagree with the majority's decision, explaining their contrary view, and sometimes predicting that the law will eventually develop in the direction they advocate. Per curiam opinion. An opinion issued in the name of the court as a whole rather than attributed to any individual judge, typically used for unanimous decisions on straightforward issues or for brief summary dispositions. Plurality opinion. An opinion that receives more votes than any other opinion, but does not command a majority, limiting its precedential value since it does not represent the view of more than half the court. En banc. The procedure by which all active judges of an appellate court, rather than the usual 3-judge panel, sit together to hear a case of exceptional importance or to reconsider a panel decision that conflicts with the court's prior precedents. Rehearing. A petition asking the appellate court to reconsider its decision, either by the original panel or by the full court sitting en banc, granted only when the court believes it may have made a significant error or overlooked an important argument. Precedent. A previously decided court case that establishes a legal principle or rule that courts are expected to follow when deciding similar cases in the future, forming the foundation of the common law system of jurisprudence. Stare decisis. Latin for to stand by things decided, the doctrine requiring courts to follow precedent established by higher courts within the same jurisdiction, promoting consistency, predictability, and stability in the law. Binding authority. Legal authority that a court is required to follow. Most importantly, decisions of higher courts within the same jurisdiction. As distinguished from persuasive authority that the court may consider but is not obligated to apply. Persuasive authority. Legal authority that a court may find helpful and choose to follow but is not obligated to apply, including decisions from other jurisdictions, lower courts, dissenting opinions, and scholarly commentary. Holding. The specific legal rule or principle established by a court's decision that is directly applicable to the facts of the case and constitutes the binding precedent that lower courts must follow in future similar cases. Dicta. Short for obiter dicta, meaning things said in passing, referring to statements in a judicial opinion that are not essential to the decision and therefore do not constitute binding precedent, though they may carry persuasive weight. Distinguish. The process by which a court explains why a precedent that appears relevant does not control the current case because of meaningful factual or legal differences, allowing the court to reach a different result without formally overruling the earlier decision. Overrule. The decision of a court to formally repudiate and set aside one of its own prior precedents, declaring that the earlier decision was wrong and will no longer be followed, typically reserved for cases where the prior rule has proven unworkable or clearly erroneous. Abrogation. The formal abolition or annulment of a legal rule, doctrine, or precedent, either by a court overruling a prior decision or by a legislature enacting a statute that supersedes the judicially created rule. Circuit split. A disagreement between different federal circuit courts of appeals on the same question of federal law, creating inconsistent results across jurisdictions and often prompting the Supreme Court to grant certiorari to resolve the conflict. Certiorari. Latin for to be informed, the writ by which the Supreme Court exercises its discretionary appellate jurisdiction, with the court granting certiorari, commonly referred to as granting cert, when at least 4 of the 9 justices vote to hear the case. Rule of 4. The informal Supreme Court practice requiring that at least 4 of the 9 justices agree to grant certiorari before the court will accept a case for review, giving a significant minority of the court the power to place an issue on the national legal agenda. Certiorari denied. The Supreme Court's refusal to hear an appeal, which leaves the lower court's decision in place but carries no precedential weight and does not constitute the court's endorsement of the lower court's reasoning or result. Ab initio. Latin for from the beginning, used to describe something that is void or invalid from its inception, rather than becoming invalid at some later point, such as a contract that was illegal from the moment it was formed. Actus reus. Latin for guilty act, referring to the physical conduct or omission that constitutes the criminal offense, paired with mens rea to establish the 2 essential elements required for criminal liability in most offenses. Ad hoc Latin for this purpose, referring to something created or appointed for a specific purpose rather than as part of a permanent arrangement, such as an ad hoc committee formed to address a particular issue. Ad litem. Latin for the suit, used in phrases such as guardian ad litem to designate a person appointed specifically to represent another's interests in a particular legal proceeding. Amicus Curiae. Latin for friend of the court, referring to a person or organization that is not a party to the case, but submits a brief offering relevant information, expertise, or perspective to assist the court in its deliberations. Bona fide. Latin for in good faith, referring to something done sincerely and honestly without deception or fraud, such as a bona fide purchaser who acquires property without knowledge of any defects in the seller's title. Caveat emptor. Latin for let the buyer beware, the traditional common law principle placing the burden on buyers to investigate the quality and suitability of goods before purchase. Significantly limited in modern consumer protection law. Certiorari. Latin for to be informed or to be made certain, the name of the writ by which a higher court calls up the record of a lower court case for review, most commonly associated with Supreme Court discretionary review. Corpus delicti. Latin for body of the crime, referring to the fundamental facts establishing that a crime has been committed, requiring proof that the criminal act occurred and that someone's criminal agency caused it before a confession alone can support a conviction. De facto. Latin for in fact, referring to something that exists or is practiced in reality, even if not formally recognized by law, as distinguished from de jure, by right, which refers to what is legally authorized or official. De jure. Latin for by right or by law, referring to something formally recognized and established by legal authority, as distinguished from de facto situations that exist in practice regardless of legal recognition. De minimis. Latin for about minimal things, referring to something so trivial or insignificant that the law will not concern itself with it, expressed in the maxim de minimis non curat lex. The law does not concern itself with trifles. De novo. Latin for anew or afresh, referring to a fresh review conducted as if no prior decision had been made, most commonly used to describe the standard of appellate review applied to pure questions of law. Dictum. The singular form of dicta referring to a statement in a judicial opinion that is not essential to the holding and therefore does not constitute binding precedent, though it may be cited as persuasive authority. Ex parte. Latin for from one party, referring to a proceeding, motion, or communication involving only one party without the presence or prior notice of the opposing party, permitted only in limited emergency or administrative circumstances. Ex post facto. Latin for after the fact, referring to a law that retroactively criminalizes conduct that was lawful when it occurred, or increases the punishment for an offense after it was committed, prohibited by the United States Constitution. Habeas corpus. Latin for you shall have the body, the name of the ancient writ commanding that a person held in custody be brought before a court to determine whether their detention is lawful, serving as the cornerstone of protection against unlawful imprisonment. In camera. Latin for in the chamber, referring to proceedings conducted privately in the judge's chambers or outside the presence of the jury and the public, typically used for reviewing sensitive evidence or discussing privileged matters. In limine. Latin for at the threshold, most commonly appearing in the phrase motion in limine, referring to a pretrial motion asking the court to rule on the admissibility of specific evidence before trial begins. In personam. Latin for against the person, referring to a court's jurisdiction over the specific individual parties to a case, as distinguished from in rem jurisdiction over a piece of property regardless of who owns it. In remir's Latin for against the thing, referring to a court's jurisdiction over a specific piece of property located within the court's territory, regardless of where the property's owner may be located. Inter alia, Latin for among other things, used in legal writing to indicate that only some of several items, provisions, or arguments are being mentioned rather than a complete listing. Ipso facto, Latin for by the fact itself, used to indicate that a particular legal consequence follows automatically from the occurrence of a specific fact, without requiring any additional action or judicial determination. Lex loci, Latin for law of the place, referring to the principle that the law of the jurisdiction where an event occurred or a contract was made governs the legal issues arising from that event or contract. Mens rea, Latin for guilty mind, referring to the mental state or criminal intent required as an element of most criminal offenses, paired with actus reus to form the two essential components of criminal liability. Modus operandi, Latin for method of operating, referring to a person's characteristic pattern of behavior or method of committing crimes, admissible in criminal cases to identify the defendant as the perpetrator of similar offenses. Nolo contendere, Latin for I do not wish to contend, a plea in criminal cases in which the defendant neither admits nor denies guilt, but accepts the punishment as if guilty, with the significant advantage that the plea cannot be used as an admission of liability in a subsequent civil case. Non sequitur, Latin for it does not follow, referring to a conclusion or statement that does not logically follow from the preceding premise or evidence used in legal argument to identify flawed reasoning. Obiter dictum, Latin for a remark in passing, referring to statements in a judicial opinion that are incidental to the decision and not essential to the holding, carrying persuasive but not binding authority in future cases. Parens patriae, Latin for parent of the nation, referring to the sovereign's, now the state's, inherent authority to act as guardian for those unable to care for themselves, including minors and mentally incapacitated persons, justifying government intervention in child welfare and similar matters. Per curiam, Latin for by the court, referring to an opinion issued in the name of the entire court rather than attributed to any individual judge, typically used for unanimous decisions or brief summary dispositions. Per se, Latin for by itself or in itself, referring to something that is inherently or automatically a particular thing without requiring additional proof of circumstances, such as conduct that is per se negligent or per se anti-competitive. Prima facie, Latin for at first sight or on its face, referring to evidence that is sufficient on its face to establish a fact or claim unless rebutted, or to a case that has enough initial evidence to proceed to trial. Pro bono, short for pro bono publico, Latin for the public good, referring to legal services provided by attorneys free of charge to clients who cannot afford representation, considered a professional obligation of lawyers in many jurisdictions. Pro se, Latin for oneself, referring to a party who represents themselves in legal proceedings without the assistance of an attorney, also called appearing in propria persona. Quantum meruit, Latin for as much as deserved, an equitable doctrine allowing a party to recover the reasonable value of services rendered when no enforceable contract exists, preventing the other party from receiving those services without paying fair compensation. Res ipsa loquitur, Latin for the thing speaks for itself, a negligence doctrine permitting an inference of negligence from the mere fact that an accident occurred, applicable when the type of harm ordinarily would not occur without someone's negligence and the defendant had exclusive control over the instrumentality that caused the harm. Res judicata, Latin for a matter already judged, the doctrine preventing the same parties from relitigating a claim that has already been fully and finally adjudicated on the merits, providing finality and preventing endless repetitive litigation. Respondeat superior, Latin for let the master answer, the doctrine of vicarious liability holding an employer responsible for torts committed by employees acting within the scope of their employment. Scienter. Latin for knowingly, referring to the mental element of knowledge or intent required for certain causes of action, particularly fraud and securities violations, requiring proof that the defendant knew their conduct was wrongful or deceptive. Sine qua non. Latin for without which not, referring to an essential condition or element without which something cannot exist or occur, used in causation analysis to identify conduct that was indispensable to producing the resulting harm. Stare decisis. Latin for to stand by things decided, the foundational doctrine of the common law system requiring courts to follow precedent established by higher courts within the same jurisdiction, promoting consistency, predictability, and stability in legal decision-making. Sub judice. Latin for under a judge or before a court, referring to a matter that is currently pending before a court and therefore generally not appropriate for public discussion or media commentary that could influence the proceedings. Sua sponte. Latin for of its own accord, referring to an action taken by the judge on their own initiative without being requested by either party, such as raising a legal issue, excluding evidence, or dismissing a case on grounds not argued by counsel. Ultra vires. Latin for beyond the powers, referring to an act taken by a corporation, government agency, or other body that exceeds the authority granted to it by its charter, constitution, or enabling statute, rendering the act void or voidable. Vel non. Latin for or not, used in legal writing as a shorthand way of framing a binary question, whether something exists or does not exist, such as the question of liability vel non. Versus. Latin for against, universally abbreviated as versus in case citations to separate the names of the opposing parties, as in Brown versus Board of Education. Voir dire. A French legal term meaning to speak the truth, used in American law to refer both to the process of questioning prospective jurors during jury selection and to many hearings conducted to determine the admissibility of evidence or the qualification of an expert witness. Alternative dispute resolution, ADR. The collective term for methods of resolving legal disputes outside of traditional court proceedings, offering parties faster, less expensive, more flexible, and more private alternatives to litigation while preserving their ability to control the outcome. Mediation. A voluntary confidential dispute resolution process in which a neutral third party, the mediator, facilitates structured negotiation between the disputing parties, helping them communicate, identify interests, and reach a mutually acceptable settlement without imposing a decision. Mediator. The neutral third party who facilitates a mediation, trained in conflict resolution techniques and communication skills, but lacking the authority to impose a resolution, serving only to guide the parties toward their own voluntary agreement. Arbitration. A private dispute resolution process in which the parties present their case to a neutral arbitrator or panel of arbitrators who evaluate the evidence and render a binding or non-binding decision, functioning similarly to a trial, but with relaxed rules and greater flexibility. Arbitrator. The neutral decision-maker in an arbitration proceeding, often a retired judge or experienced attorney with expertise in the relevant subject area, who hears the parties' presentations and renders a decision called an award. Binding arbitration. An arbitration in which the parties agree in advance that the arbitrator's decision will be final and enforceable as a court judgment, with extremely limited grounds for judicial review or appeal of the award. Non-binding arbitration. An arbitration in which the arbitrator's decision serves as an advisory opinion rather than a final resolution, allowing either party to reject the award and proceed to court if they are dissatisfied with the outcome. Arbitration agreement. A contract provision or standalone agreement by which the parties commit to resolving disputes through arbitration rather than litigation, enforceable under the Federal Arbitration Act, and increasingly common in consumer, employment, and commercial contracts. Arbitration clause. A provision included in a contract, often in fine print, requiring that any disputes arising from the agreement be resolved through arbitration rather than litigation, typically also specifying the rules, forum, and location of any arbitration. Arbitration award. The arbitrator's final written decision resolving the dispute, which in binding arbitration has the force of a court judgment and may be confirmed, vacated, or modified by a court on extremely limited grounds. Confirmation of award. The judicial process of converting an arbitration award into an enforceable court judgment, allowing the prevailing party to use the court's enforcement mechanisms, such as garnishment and levy, to collect if the losing party does not voluntarily comply. Vacating an award. The narrow judicial remedy of overturning an arbitration award, available only on limited grounds specified by statute, such as fraud, corruption, evident partiality of the arbitrator, or the arbitrator exceeding their authority, reflecting the strong federal policy favoring arbitration. A rules. The procedural rules of the American Arbitration Association, one of the most widely used arbitration institutions, governing the administration of arbitration proceedings, including the selection of arbitrators, filing fees, discovery, and conduct of hearings. JAMS, Judicial Arbitration and Mediation Services, a leading private dispute resolution provider offering arbitration, mediation, and other ADR services, commonly specified in arbitration clauses for complex commercial disputes. Panel arbitration. An arbitration heard by a panel of 3 arbitrators rather than a single arbitrator, typically used in high-stakes commercial disputes where the parties want the additional safeguard of multiple decision-makers. Sole arbitrator. A single arbitrator appointed to hear and decide a dispute, common in smaller commercial matters and consumer disputes where the cost and complexity of a 3-arbitrator panel is not warranted. Claimant. The party who initiates an arbitration proceeding by filing a demand for arbitration, analogous to the plaintiff in litigation, who bears the burden of establishing their claims against the responding party. Respondent. The party against whom an arbitration claim is filed, analogous to the defendant in litigation, who must file an answering statement and present a defense to the claimant's allegations. Demand for arbitration. The formal document initiating an arbitration proceeding, setting forth the nature of the dispute, the relief sought, and the basis for the arbitrator's jurisdiction, filed with the arbitration institution and served on the opposing party. Arbitrability. The threshold question of whether a particular dispute falls within the scope of an arbitration agreement and is therefore subject to arbitration rather than court proceedings, decided by a court unless the parties have clearly delegated this question to the arbitrator. Conciliation. A form of ADR similar to mediation in which a neutral third party, the conciliator, takes a more active role in proposing solutions and bridging the gap between the parties, used particularly in international commercial and labor disputes. Neutral. The generic term for the impartial third party who facilitates or decides a dispute in any ADR proceeding, whether serving as a mediator, arbitrator, conciliator, or neutral evaluator. Early neutral evaluation. An ADR process in which a neutral expert evaluates the strengths and weaknesses of each party's case at an early stage of the dispute, providing an objective assessment that often facilitates settlement by giving the parties a realistic preview of likely outcomes. Mini-trial. An ADR process in which senior executives or decision-makers from both sides, who have authority to settle, hear abbreviated presentations of each party's case from their attorneys, followed by negotiations aimed at reaching a business resolution without full litigation. Summary jury trial. An ADR technique in which the parties present abbreviated versions of their cases to an advisory jury that renders a non-binding verdict, providing the parties with a preview of how a real jury might decide the case and facilitating informed settlement negotiations. Negotiation. The most basic form of dispute resolution involving direct discussion between the parties or their attorneys aimed at reaching a mutually acceptable resolution without the involvement of any neutral third party. Settlement agreement. The binding written contract memorializing the terms of a resolution reached by the parties, whether through negotiation, mediation, or other ADR process, which may be submitted to the court for approval and incorporation into a consent judgment. Consent judgment. A court judgment entered by agreement of the parties, incorporating the terms of their settlement and giving it the force of a court order, allowing enforcement through the court's contempt power if either party fails to comply. Confidentiality. A fundamental feature of most ADR processes, particularly mediation, protecting all communications, offers, and admissions made during the proceeding from disclosure in subsequent litigation, encouraging frank discussion without fear that candid statements will be used against a party later. Without prejudice. A designation applied to settlement communications and offers indicating that they are made solely for the purpose of resolving the dispute and may not be admitted as evidence of liability or the value of the claim if negotiations fail and the case proceeds to trial. Med-Arb. A hybrid ADR process combining mediation and arbitration in which the parties first attempt to resolve their dispute through mediation and, if unsuccessful, the neutral transitions to the role of arbitrator and renders a binding decision on the unresolved issues. ArbMed. The reverse hybrid of Med-Arb, in which the arbitrator first renders a sealed arbitration award and then attempts to mediate a settlement, revealing the award only if mediation fails, using the arbitration result as leverage to encourage settlement. Online Dispute Resolution, ODR. The application of ADR techniques through digital platforms and technology, allowing parties to resolve disputes remotely through video mediation, online arbitration, and automated negotiation tools increasingly used for e-commerce, consumer, and low-value disputes. UNCITRAL rules. The arbitration rules developed by the United Nations Commission on International Trade Law, widely used in international commercial arbitration and investor-state disputes as a neutral set of procedures not associated with any particular national legal system. New York Convention. The 1958 Convention on the Recognition and Enforcement of Foreign Arbitral Awards, ratified by more than 160 countries, which requires signatory nations to recognize and enforce arbitration agreements and awards made in other member states, making international arbitration awards more reliably enforceable than foreign court judgments. International arbitration. Arbitration conducted between parties from different countries or involving cross-border disputes, typically governed by specialized rules and institutions, such as the ICC, LCIA, or ICSID, designed to provide a neutral forum independent of any single nation's legal system. Investor-State Dispute Settlement, ISDS. An arbitration mechanism included in many international investment treaties allowing foreign investors to bring claims directly against host governments for treaty violations, such as expropriation without compensation or discriminatory treatment, before an international arbitral tribunal.